Good afternoon. My name is Sasha Carlson. I am the Executive Director of ACOS. At ACOS, our goal is to network and educate the international accountant in the USA. Welcome to our webinar, Legal in the US, Immigration Issues and Strategies for Professional Accountants. Before we begin, I would like to remind our audience that you can download the presentation from the handout section in the webinar. We will also take some questions during the webinar, so please submit them through the question pane. Any questions we don't address during the session will be reviewed after the webinar. Please do keep in mind that our panelists can't provide specific legal advice, so they will respond in a general manner where possible. Also, please keep the follow-up email we send as proof of your attendance. Members are responsible for determining if the session would qualify for professional education through your accounting body. Okay, that's it for housekeeping. So all our members here at ACOS share a similar experience, that of being a foreigner at one point here in the USA. On a personal level, this experience is complicated. While I have lived in the States for over a decade, there's a simmering uncertainty as to my family's stability in this country. This uncertainty is really highlighted when I return to Canada, my home country, when I go there for vacations. Once I land there, I suddenly feel secure that no one can tell me that I'm no longer allowed to work or make a home here, as could happen here in the States. I'm not a citizen of the US. I don't have a green card. I work here on a TN visa. And many of our members have shared similar situations, companies not renewing visas, immigration officials denying entry. This lack of control creates a stress that adds monumentally to a burden of trying to build a successful career and life here. So this session seeks to share some current and important information regarding different types of visas, both non-immigrant and immigrant, so that our audience and members can be educated on some options. We are so grateful to Fragomen Worldwide for sharing this information with us, and we hope that you'll be able to get a better understanding of some of the issues and strategies for, staying legal here in the US. So our presenters today are Martine Cuomo and Audria Golding. Martine is a partner in Fragomen's New York City office, where she manages teams working with clients who require US and worldwide immigration advice and assistance. Martine's been practicing US immigration law for over 20 years and has been with Fragomen for 18 years in the New York office. Martine works with clients across a wide range of industry sectors, including financial services and accounting, technology fields, pharmaceuticals, consumer products, and fashion industries. Audria is a partner in Fragomen Canada's Toronto office, where she manages the US consular and cross-border practice, as well as working with Canadian immigration teams. Audrey has been practicing exclusively in Canadian and US immigration law for over 20 years and has been with Fragomen for 14 of those in the US. Audrey works with clients across a wide range of industry sectors, including financial services and accounting, as well as technology and the entertainment industry. I'm going to pass the session over to your capable hands now, Martina and Audria. Thank you so much.
Thank you, Sasha. So, Audria, start it off.
Sure. Thank you, Sasha, and thank you to the members of ACOS that are on the phone. We're very happy to be presenting to you this morning and look forward to a dialogue with you on the burning questions associated with U.S. immigration. Today, the organization has asked us to talk a little bit about immigration options and immigration in general, as well as permanent residency options for members of ACOS and your family members who are inside the U.S. To start, we will follow the agenda that's listed on the slide that Sasha has up. But by way of introduction, we'll give you a little bit of background on Fragomen and why we were asked to speak with you today. As some of you may know, the next slide, Sasha. Fragomen is a global immigration firm. We have been practicing in the area of immigration and nationality law exclusively since 1951. We have over 50 offices worldwide, and we support movement into roughly 170 countries globally. We work with many of your organizations to help you transfer into multiple jurisdictions based on professional qualifications. And or firm is known for its size, not only size, but also diversity. We're proud of the record that we have of the diversity of partners and professionals that work with folks from all over the world to help facilitate the immigration and mobility process across borders. We're going to start with some general information on or overview of immigration processes to the United States. So I'm going to turn it over to my colleague Martine, and she'll cover that area for you.
Perfect. Sasha, do you mind going to the next slide? Hi, everybody. So this is Martine Cuomo, and as Audrey said, we're thrilled to be speaking with you and happy to give you some background on U.S. immigration. And as Audrey and I have both been practicing over 20 years, we can certainly say that the past 18 months in U.S. immigration has been one of the most exciting and, I use that term loosely, interesting periods of U.S. immigration. Really, under the Trump administration, immigration has changed significantly. So we wanted to first put up this slide here that talks about the key government agencies that are involved with U.S. immigration, because there are far-reaching impact of all the various immigration and visa matters that we handle. You'll see that we work with the Department of Homeland Security, which used to be known as the INS. It's divided up into 3 different groups. The U.S. Citizenship and Immigration Services, which is where petitions get filed, basically we say on the papers, and where green card cases are filed. Customs and Border Protection, that's who you speak with every time you come into the U.S. Then there's Immigration and Customs Enforcement. These are the people who really, sort of like the police force, they'll come to, whether it's on site to your employer's site and want to investigate and see what's going on. They'll also do lots of fraud investigations. We also deal with the Department of Labor, and that is for whether it's an H-1B, an E-2, anything that requires testifying regarding the wages being paid to foreign nationals and basically not impacting U.S. workers. And then also green card processes. The majority of green card processes also work with the Department of Labor. Then we have the Department of State, which is oversees all the U.S. embassies and consulates worldwide. You might think that as Canadians, since you're visa exempt, you're not really dealing with the Department of State, but you'll see later on in the presentation when we talk about green card processes, it's actually the Department of State that is significantly involved with when you're going to get your green card. But we'll get there in just a minute. Sasha, if you don't mind going to the next slide. The reason that I started off saying that the past 18 months have really been an interesting period in U.S. immigration is because of our current administration, the Trump administration. There are a number of priorities which people, you've probably seen in the newspapers and on the news, and you might have also felt the impact yourself. You know, of course, funding for the border and enforcement infrastructure and personnel, including a wall between the U.S. and Mexico, is sort of all over the papers. You'll see in a few slides that not only is there a physical wall that the Trump administration has been talking about, but there's actually a wall that's being built up by the enforcement of policies that have been the priority for the Trump administration. And the wall that I'm talking about is a much more restrictive approach to granting visa benefits or immigration benefits. We'll get into that in just a minute. The points-based migration system is something that the Trump organization has been talking about, and for that, they're actually looking to you, our northern neighbor up in Canada, because Canada has already, as have other nations around the world, adopted a points-based immigration system. The U.S. has generally been focused on family immigration, which you'll see the 2 points down where the Trump administration is interested in limiting family-based sponsorship and chain migration. Basically, you know, once somebody's in here, then sponsoring their immediate and not so immediate family members to come to the U.S. So the U.S. immigration system has been based on family immigration, but now the focus is more on employment-based, and a points-based migration system is a topic of discussion. The Buy American, Hire American executive order has had significant impact. This current administration not only do they issue executive orders, but we also have a president who tweets out what is of interest to him, and therefore his administration. So you'll see that this is a significant, what had been seen as a little innocuous about a year ago is now actually rearing its impact significantly in current decisions that we're seeing. And of course, the last bullet point, increased federal enforcement powers, including greater interagency and state-local collaboration. So that goes back to the previous slide when we talked about the various different government agencies that are involved with immigration. So Department of Homeland Security, Department of Labor, Department of State, as well as the Trump administration is trying to bring in state and local collaboration with U.S. immigration. U.S. immigration, of course, is a federal law, whereas the Trump administration wants the local, state and local law enforcement to also become involved. Sasha, if we can go to the next slide. You'll see that, I'm not sure if all of you recognize this person. This is Steve Bannon. And Steve Bannon was an advisor to President Trump right when during his campaign and when he had, after the inauguration. This picture was taken shortly after the inauguration. It's from January of 2017. Steve Bannon is notoriously a secretive person and doesn't really like to show his hand in any manner. However, shortly after the inauguration, somebody must have, I don't know who it was, but somebody must have been visiting his office and decided to take a selfie. That person was cropped out, but this photograph was circulated. And it really sent chills down immigration practitioners' spine because you'll see the part behind his head is a little bit cut off, but you can see some of them focus on, big issues such as repeal and replace Obamacare, pledges of tax reform, 10% repatriation tax. Those are, in and of itself, huge issues. But that's nothing compared with the longer list on the right-hand side over Steve Bannon's left shoulder and the list that's much more visible. This focuses, the top says pledges on immigration. And if you go right down the list, this is everything that Trump was talking about during his campaign speech, and now we're seeing he's actually been implementing them since he's been president. You'll see canceling federal funding to sanctuary cities, suspending immigration from terror-prone regions, implementing extreme vetting, suspend Syrian refugee program, an increase of 5,000 border patrol agents, tripling the number of ICE agents, Immigration and Customs Enforcement, building the border wall, terminating Obama's 2 illegal laws, which are, the childhood arrivals. Those are sort of the dreamers that we talk about, and childhood arrivals in the U.S., and also parents of Americans. So these are the things that get a lot of print in the newspapers and also, in newscasts. But you'll see on the next page, there's really been a bit of a different impact on business immigration that doesn't get so much press. So this is just a timeline of last year, what sort of major impacts to business immigration. And of course, it's still ongoing. We'll get to the current year in just a minute. But just to give you some background, if you look under Q1, so this is right after the inauguration, you'll see there's a March 6, 2017 executive action state talking about, or it's an extreme vetting memo directing all of the agencies we mentioned to adopt heightened screening protocols. So this is petitions that are getting reviewed by immigration. This is people who show up at the U.S. border, whether flying in or driving in. You'll see the under Q1, there's a March 31st memo that rescinds, guidance that had been around for 17 years, talking about computer-related positions, saying that computer programmers would qualify for specialty occupations. And a specialty occupation means that the job requires a bachelor's degree and the person possesses one. So you'll see that this memo has been rescinded after 17 years. The memo also focuses on the offered wage. So I don't know if anybody was in the H-1B cap season last year, but the number of requests for evidence from the government went up by about 45%, and the majority of those requests for evidence focused on the wage that was being offered to H-1B visa applicants. And the immigration's approach was to say, well, if you're being paid a level 1 wage, then clearly your position must not be a specialty occupation. So that was just Q1. Then we go to Q2, and you'll see the April 18th, 2017 Buy American and Hire American executive order. This has had a significant impact on U.S. workers. The result has been restrictive interpretations, again, to any visa or immigration benefits. It really directs all of the government agencies to amend how they review petitions. You know, on the face of it, what American is going to argue with Buy American and Hire American? It seems fairly innocuous. But as we've seen over the past year, the implementation has really been restrictive to U.S. business immigration. Q3, there was again some notable points, but then Q4, we talk about October 23rd was a significant memo from the U.S. Citizenship and Immigration Service that again rescinds granting deference to prior approvals. This means that if somebody's been in the U.S., let's say, to Sasha's introductory point, she's been here for a number of years on a TN, but every time she goes to get her TN renewed and extended, what the government had done prior to the current Trump administration, they granted deference to prior approvals by their colleagues, right? If my colleagues in USCIS or at the border had approved a case and it's similar facts, same employment, same employee, maybe a promotion, maybe a few more responsibilities, normally you'd think it should be a fairly straightforward approval. However, the the October 23rd, 2017 memo rescinds deference to prior approvals, and now every time an extension is filed, the Immigration Service or the border officers, they have to review the petition as if it's completely new. They don't need to give deference to any prior approvals. So you can see, and we'll go on to 2018 in just a second. Actually, Sasha, if you don't mind flipping to the next slide, you'll see that Congress has not made any major legislative changes in U.S. immigration. There's no significant legislative changes or regulatory changes, but really it's been the power of the president under the executive branch to change process and policy and the adjudication standards. So this has been a really tumultuous year and a half in U.S. immigration. From those who supported Trump, they think it's been quite a lots of progress has been made because a lot of Trump's promises from the campaign have been implemented, and he's achieved many of the campaign promises. The Trump administration, as you'll see in 2018, continues to reshape business immigration. You'll see, in May, there was a policy memo that talks about, I don't know if there's probably not students on the line here since you're all in the ACOS organization and probably working already, but the June 28th, 2018 policy memo that talks about notices to appear if your application is denied and you have no underlying status. So, Sasha, I don't want to, I hate to use you as an example, but just because the membership knows you and you had confirmed you're here under a TN, yep. Let's that if Sasha's TN is extended, let's say instead of going to the border, but you file an extension with immigration while you remain here in the U.S. If immigration, decides not to give any prior deference and decides that you no longer qualify for a TN, and they were to deny your TN petition, well, with this June 2018 policy memo, if your TN were denied and you didn't have another underlying status, let's say if it was filed towards the end of your validity period rather than sort of as early as possible, which is of course the recommendation, but let's say it was denied and you were already beyond your I-94 validity date and your TN extension was denied, at that point you'd have no status in the U.S., and the government, under this memo, would feel that they were able to issue a notice to appear. And a notice to appear is basically the first step in a deportation or in a removal proceeding. So this is a fairly new policy memo, and actually as of this Thursday, the 27th, September 27th, the government has indicated that they will issue an update on how they expect to implement this policy memo. So U.S. business immigration is constantly evolving, and I mean, I hate to I don't want to sound like Chicken Little that the sky is falling and U.S. immigration is completely terrible. We're still getting cases approved. People are still here. Visa matters are still getting extended. Green cards are still getting authorized. But really, with all these memos and executive orders, sort of the takeaway here is to really work closely with your immigration legal counsel and make sure that cases are addressed as early as possible, and that the evidence provided is as strong as possible. Because with this heightened scrutiny and focus on legal immigration, it's just really important that everybody sort of has the background that immigration is no longer sort of an easy sort of process to go through with expected results. It really is something that is taking a lot more time and attention and focus on the employee's part as well as the employer's part in order to ensure that you have your uninterrupted U.S. Work authorization and visa status, and also, of course, for the green card processes. So again, I don't want to sound like Chicken Little. It's just, it really is a different environment than what it had been a year and a half ago, where there were some downright business immigration friendly policies that had been issued. So it's a different administration and a different level of focus that needs to be paid to U.S. visa and immigration matters. So with that as a background, Sasha, we can go to the next slide. There's a lot of material here, so we're just going to keep moving. If there are any questions, did you want to take a minute here, or do you want to save them for the end?
I'll just jump in here for a second. We have had a couple of questions. One is more related to green card processes, so I think we'll wait till we get to that section in our session. And then Harvey had just made a comment that TNs are not extendable. They expire, and new ones must be issued. I'm sure you'll go through that again, but just to clarify that point, if you can, right now.
Yeah, absolutely. So when we get to the TNs, then Audrey is going to go into the TNs with a bit more detail. And also there's been some updates to the TN. Back on the previous slide where we had the 2017 year in review, there was also a memo that came out, USCIS guidance December 2017. So certainly you're right in that TNs do need to be presented anew, or whether at the border or whether at the immigration service. So this is just sort of. Are there any other points or questions that you wanted to go to before we get into the non-immigrant visa specificity?
No, I think we're good to go on. Thank you.
Sure. So here's this slide here is just sort of a brief overview of the non-immigrant, well, really of U.S. immigration. And again, to Sasha's earlier point, this overview today is it's an overview of U.S. immigration. It's not specific legal advice or guidance, and that, as I said, just based on the sort of updates under the Trump administration. For specific legal advice and guidance, you'll want to work with your immigration service provider and make sure that you have advice that's specific to the facts of your case. But so this is just an overview. U.S. visas, we have non-immigrant visas, and we have immigrant visas. Non-immigrant, of course, are your the temporary visas, TNs, O's, H's, L's, E's. These are the non-immigrant, meaning that they will not result in a green card and permanent residency in the U.S. And of course, you maintain your non-immigrant status while you're pursuing the green card generally. And of course, the green card is the immigrant process. So the non-immigrants, again, are coming to the U.S. temporarily. There's sort of an alphabet soup of visas, A through V. We're not going to go through every visa category. We've just selected sort of the most frequently used visa categories. And I know that there had been some questions in advance, and Sasha shared those, so we did add a slide on the E2, which somebody had inquired about, but we'll get to that in just a minute. The visa category has to match with what the proposed U.S. activities are going to be, right? So if you're simply visiting the U.S. as a business visitor and you want to go to Disneyland, well, then you're going to come in as a visitor to the U.S. You're not going to have any of these work authorized categories. But if you're coming into the U.S. to work, then of course your immigration service provider needs to dig in to see what it is that you'll be doing in the U.S. and get all the circumstances and facts of your proposed U.S. work and stay to determine what visa category you're eligible for, and of course if you meet the criteria for it. Setting expectations is always an important aspect. There's the time required to prepare the visa petition or application. And then there's the time that the government requires to make a decision. A lot of your applications can be submitted right at the Canadian-U.S. border to U.S. immigration officers that are stationed at what are called Class A ports of entry. And so the adjudication can happen very quickly. Or if you're in the U.S. and petitions are being filed with the U.S. Citizenship and Immigration Service, then you have to allow for the adjudication time. Sometimes it can be as quick as 15 days with what's called premium processing. Sometimes it'll take, 4, 5, 6 months for the government to make a decision. And then the government decision-making process itself and considerations, that was a lot of what we went under with the intro to the Trump administration. So Sasha, if you want to go to the next slide. We'll talk about H-1Bs just briefly so that everybody has an idea of the H-1B visa category. This is sort of for Canadians. Clearly the TN, Trade NAFTA, is of great importance, and Audria, as I said, is going to go into that. But we're going to start quickly with the H-1s, and this is probably the second most popular visa category. TNs, H's, and L's are sort of the primary visa categories that we'll go over. H-1Bs are for persons who are going to be employed temporarily in a specialty occupation. And a specialty occupation is really under, as I said earlier, come under much greater scrutiny by the government. Specialty occupation is an occupation that requires, at minimum, the theoretical and practical application of highly specialized knowledge and attainment of a bachelor's or higher degree or equivalent for that specific occupation. So let's say that you are going to be working in the U.S. as an accountant. Well, of course, to work as an accountant in the U.S., you'll need to have an accounting degree. So that's really a very clear eligibility for H-1B, because there is the occupation itself, which requires the theoretical and practical knowledge. And then, of course, it's not any degree that's going to qualify you to work as an accountant. It's really going to be an accounting degree. Lots of employers might sort of expand that, but you don't want to expand the eligible degrees to perform a job in the U.S. to such an extent that the government would come back and say, oh, well, it's not a specialty occupation because it's not that you have to have a specific degree or, specific or closely related degree in order to perform that job. So when you think of an operations research analyst, right? So that's one of the occupations in the U.S. And if it's really a broad variety of degrees that the employer will accept for that operations research analyst position, we've had lots of inquiries from the government. We call them requests for evidence, where they come back and say, well, you know what, it's such a broad category and you'll accept so many different degrees. How is it that that would qualify as a specialty occupation? And so this, to my earlier point, we really need to delve into the specific facts of a situation, of the employer, of the foreign national, and make sure that we can establish to the immigration's satisfaction that a position and the foreign national qualify for that specialty occupation H-1B. Sasha, if you want to go to the next slide. Just generally, the requirements for an H-1B. Again, we talked about the degree. There has to be a nexus between the degree that's been earned and the position in the U.S. It's not just that people have to have a degree in order to qualify for an H-1B specialty occupation role in the U.S. The government will allow experience, professional work experience, to help qualify the person to have acquired the equivalent of a U.S. bachelor degree. So the government, USCIS, basically agrees that 3 years of professional experience can equate to 1 year of university level experience. So really, after 12 years of professional progressive experience, we can obtain equivalencies to a U.S. bachelor's degree and qualify people for H-1Bs. We work with outside vendors who review the professional experience and employment verification letters and make that determination if the experience can wholly or in part qualify somebody for the equivalent of a bachelor's degree. H-1Bs are generally valid for up to 6 years. Initially, it'll be 3 years. You'll get a 3-year extension. The only way to go beyond that 6 years is if you have started the green card process early enough in the H-1B process that you'll be allowed to extend beyond the standard 6 years. There is labor condition applications, the attestations there. We work with the Department of Labor to get the labor condition application certified, and that is step 1 of the H-1B. And then the H-1B is filed with U.S. Citizenship and Immigration Service. There's limited spousal employment, and it's only allowed if somebody is far enough along in the green card process. And that, of course, spousal employment under the H-1B is another area that's come under scrutiny with the Trump administration, and we're not sure if that's going to be ongoing or if it's going to be rescinded as well, but it's possible it might be rescinded. Sasha, if you want to go to the next slide. Special considerations with the H-1B. These are just specific, if a license is required for an H-1B, then of course we have to establish that the person has that license. Or, there's a special exception here for H-1Bs for accountants without a license, as long as they're working under the supervision of a licensed person here in the U.S. Let's see, H-1Bs have very specific requirements with the LCA, the labor condition application. If there is a change in the work site, if there is a change in the responsibilities, if there's a change in the employing entity, if there's a reduction in hours from full-time to part-time, if there's a reduction in salary. These are all changes that can happen with employment and that can significantly impact H-1B eligibility. So if anybody's on an H and if there's been changes to your employment, you want to touch base with your immigration service provider and let them know about the changes so that they can determine if there's any impact to the eligibility for H-1B visa status. If we can skip to the next slide, and I'm cognizant I want to move through this a little bit more quickly. So just to say the H-1B cap, there's an H-1B cap. There's only 65,000 H-1Bs available to those with bachelor's degrees annually, and then there's an additional 20,000 to those with a master's degree as long as it's a U.S. master's degree. So let's say there's a total of about 85,000 H-1Bs available each year. And Sasha, if you want to go to the next slide. Unfortunately, the odds with only 85,000 H-1Bs, the odds are not very good to get an H-1B. It's generally less than a 50% chance of getting an H-1B. You'll see the odds from last year. And when we say fiscal year 2018, the fiscal year 2018 H-1B visas were actually filed April 1st, 2017, or really April 3rd through April 7th, 2017, because you file in April, and if selected and approved, then it becomes active in October of that year. So October is the beginning of the fiscal year for immigration. So fiscal year 2019 H-1B cases were already filed April 2nd through 6th of 2018. Those who were selected and approved can start their H-1B status in about a week, October 1. And oddly enough, there are still cases that were filed in April for which the government has indicated they were selected in the lottery. So that's good news. But yet the government still has not made a decision. They haven't issued a request for evidence. They haven't issued an approval. They haven't issued a denial. So we're still sitting and waiting for the government to make decisions on cases that were filed in April of 2018. And what's even crazier is that cases that were filed in April of 2017 that were selected, for which we received a request for evidence and for which we responded just now, almost a year and a half later after filing, we're finally getting approvals on those cases. So the government timing with all these different memos and executive orders has really gone awry over the past 18 months. But again, it's just important to stay in touch with your service provider to make sure that you remain in status while here in the U.S. If you want to go to the next slide, the TNs. Finally, sorry for all my talking. I'm going to turn it over to Audria here to talk about the TN trade NAFTA visas.
Thanks, Martine. Thanks for all that detail. And I think that's probably a visa category that's really relevant to a lot of the folks on the call. And one of the other ones that Sasha mentioned is also an important one for accountants in the U.S. is the TN visa. So I won't belabor the requirements too much, but as many of you know, the TN visa is still available, notwithstanding what we read in the news about NAFTA negotiations at this time. But the TN visa, as you're aware, that was brought into effect in 1994, is a visa that allows citizens of Canada or Mexico to apply for a professional work authorization to work in an occupation that's listed in the NAFTA schedule or appendix of occupations. The occupations are run in about 66 occupations. And so anybody applying for a work authorization under that category has to fit within the occupations there. Importantly for your organization, of course, accountant is one of the first occupations that's listed in the NAFTA. And of course, whenever you have an occupational classification for a professional work visa, just like the H-1B, there are typically some standard educational or experience requirements that go along with qualifying for that type of visa. So the ones that have really been most frequently used by folks in the accounting profession, as I mentioned, have been the accountant, of course, which requires the degree or a licensure in one of the countries. The economist classification is one that has also frequently been used based on the job. The nature of the job that is sometimes aligned to accounting or financial analysis. And mathematician is also a NAFTA category that is quite frequently used by folks in their profession. There were two occupations, the two occupations that were added after NAFTA were introduced, that were also helpful to expanding the category back in, I think, the early 2000s. Of those, one was actuary. So it's an occupation that is important to the profession and is something that is used quite frequently. If you go to the next slide, Sasha, since most of you are familiar with the TN visa, you may, in talking to colleagues, notice that there have been some, significant adjudication trends that have impacted how people are processed for TN visas when people are either applying for the first time or to get new visas at the port of entry, or if you're filing for extensions inside of the United States. So there were some trends in recent years that we thought were quite facilitative of people getting TN visas. One that may have been utilized by many of you was, in October 2012, there was a major change by the U.S. Immigration Service when it started to accept petitions inside of the U.S. for Canadian citizens who were seeking TN classification to get an approval notice before they went to a port of entry, meaning an airport or a land border, to apply for that TN visa. And that was quite important because people oftentimes would go to a port of entry and planning their start date with a firm or a company, and ran into issues with either qualifying for that classification based on the job description or based on the based on the educational requirements. And this gave people some level of comfort with respect to coming in at the port of entry because the USCIS had reviewed and had approved that job and the individual for the classification before showing up at the border. However, what we've seen, as Martine talked about at the beginning, is that since the new administration has come into effect, there has been, and this has accompanied the pronouncement for the U.S. to either renegotiate or withdraw from NAFTA. There has been some moves to really look at the mobility provisions of the TN and to restrict it somewhat so that it comports with the administration's view that jobs should first be offered to U.S. workers, and any work authorization category that may limit or restrict the availability of employment opportunities to U.S. workers should be looked at closely by officers when adjudicating cases. So one of the bigger ones, as Martine mentioned in October 2017, was the memorandum explaining that to immigration officers that there was no longer any deference to be paid to prior approvals. And then subsequently, in December 2017, the USCIS issued guidelines limiting the occupations that could be considered under the TN economist category. And this was important because while there are individuals who were performing positions such as a financial analyst and other occupations that are important to your industry, they may not have had the specific degree that was required by the economist category, and so another degree could have qualified them for a related occupation. That is no longer available, and so people have to be very careful if they've previously held economist classification or seek an economist classification to make sure that their degree is related, but also that their job duties align with what the government looks to for defining who is an economist. And regard for that is usually taken from the Department of Labor's Occupational Outlook Handbook that guides the officers in making that decision. As Martine talked about, certainly with the H-1B, we've also seen that there has been increased scrutiny of educational requirements and the relatedness of the degree, as I mentioned, for qualifying for the accountant or for the economist or similar occupations. And many of you may have experienced this in the past, if you may have been awarded degrees where in for example, commerce or a similar degree field that is not which is more common in other countries than the United States. And while the while the nature, the coursework and is related to the field of accounting or a similar field, sometimes that field of commerce has not been recognized as being sufficiently related to get that classification. And it's important to work with your immigration provider or your HR to really flesh out your individual coursework and to be able to demonstrate that your coursework in fact relates to that occupation, so that that classification that facilitates your work authorization can continue. And then one of the other things for Canadians, especially that we see with respect to the TN visa, is that the officers are increasingly enforcing the requirement that people demonstrate their non-immigrant intent. So while the TN visa can be granted in 3-year increments, and new TN visas can be applied for, to continue employment in the U.S. It really is a visa that requires you to demonstrate that you are not seeking to permanently reside in the United States. And while people may have TN visas for over 10 years or decades, longer than that, we do see that there is an increased interest in by immigration officers in having people demonstrate that they do have either a residence or an intention or ability to return to their home country, should their TN employment come to an end. And that is something that has, caused frustration at ports of entry with applicants on occasion, because oftentimes there are not a lot of ties that are retained in the home country while working in the United States. But I think it's important that people should continue to plan when traveling, to be prepared to answer that question about residential ties or financial ties in the home country when seeking TNs at the port of entry. Sasha, we'll move on to the next category of the L1 intracompany transferee. And many of you also may be quite familiar with this category, which is really reserved for people who are being transferred into the United States within their multinational organization. And so it does require that there is an intracompany relationship, meaning that your employer is one that has a qualifying corporate relationship with, your employer in the U.S. has a qualifying corporate relationship with an entity in your home country or another country where you have previously been employed. And of course, there are special provisions for U.S. partnerships, which are members of internationally recognized accounting or consulting firms, pretty commonly relied on by the Big Four accounting firms, so that it is more easily demonstrated that there is a qualifying corporate relationship, even though some of those entities are independently owned. And so you do have to have that 1 year of experience with one of those entities abroad, and you have to be coming in an executive or managerial position within your field, as well as a specialized knowledge or a specialized knowledge capacity. And of course, you'll see that there are specific durations on that on those visas as well. I know we're coming up on time, so I won't go into too much detail on the next slide, Sasha, which is the E1 and E2 visas. That, of course, typically relates to folks who may be seeking to invest in a business or to set up a business that may involve the provision of professional services in the accounting or related fields. Or people who are of import or have specialized knowledge or are essential workers from the financial services in those companies as well. So we won't go into that, but just mention that as an option should you need to consider that if there are issues with maintaining another visa status in the U.S. in the future. And then the next slide, Sasha, may be of interest to many folks as well on the call, which relates to the E3 visa. And so folks who are from Australia, who is a citizen or national of Australia, can also seek an E3 visa. is to work in what's called a specialty occupation, as well as Martine had defined it earlier under the H-1B classification. However, it's a much simpler process, typically speaking, to get an E3 visa. And typically, folks in, again, the accountancy and related fields typically are coming to work in what would be considered a specialty occupation for the purposes of this visa. Of course, it does require that the individual have a bachelor's degree or equivalent. But for those of you who, have citizenship in Australia and have that professional background from that country, it is quite straightforward, because you are able to apply at a U.S. embassy or consulate overseas, not just in Australia, but abroad generally, as long as you have the citizenship for that classification. And it's another one of those visas that also provides for spouses to be able to apply for work authorization to the U.S. So it's been very facilitative for folks who have come into the accounting field from Australia as well. I'm not sure if we'll have time to cover permanent residency, Martine, but you may want to chime in on that, and before we take some questions, and then see if we need to clarify anything.
Sure. I think actually we're going to do some NIV questions, non-immigrant visa questions that Sasha has. And I was actually going to spend just a few minutes on the green card process, because anybody who is in the green card process, you're probably going to be working closely with your immigration service provider. And it's so fact specific that we won't go into a lot of detail with the green card process. But Sasha, did you want to put out some questions that you've received?
Sure. Thanks very much, you guys. I am cognizant of the time. So I'll just ask a couple of the questions here. We didn't specifically cover these individual visas, but we did talk about the L's and the H categories. We have a question saying, what's the difference between an L2 and an H2 visa? Are there any differences in work permits? Is that something you can cover?
Sure. So an L2 is a dependent of an L1. So
Okay.
if the L1 is coming into the U.S., then the L2 is either the spouse or child under the age of 21. L2 spouses are eligible to apply for a work authorization, employment authorization document. So let's say the family comes into the U.S., the L1 is authorized to work incident to the L1 status. The L2 comes into the U.S. And then has to apply for work authorization, and it takes about 3-4 months after coming into the U.S. to get that L2 employment authorization document. And it's only for spouses, not for the children.
Okay.
An H2, I think the person was actually referring to an H4, which is the dependent of an H1B.
Okay.
So it's the same thing. The H1B worker comes into the U.S. and they're authorized to work incident to status. The H4 spouse or child under the age of 21 also comes into the U.S. The H4 spouse can only apply for work authorization if the H1B employee is already into the green card process and sort of far enough along, probably a year or two into the green card process, before the H4 spouse is eligible for work authorization. So again, since it deals with the green card process, this is best reviewed sort of on an individual basis.
Great. Okay. I've got a couple of questions regarding TN visas here. One is if a Canadian working in the U.S. on a TN visa starts a family in the U.S., what issues should they consider?
That sounds sounds a little bit personal. I'm not sure what the question means about starts a family. I mean, that it's really not an immigration issue, but it depends on where your spouse may be from. Maybe the question is asking if by virtue of having a family here,
Right.
is there an ability to remain in the U.S.?
Yeah.
Not particularly. Again, as I mentioned, a TN is a non-immigrant visa. So if you opt to apply for a TN and you're working on that visa, if the TN employment does come to an end for whatever reason, there is a requirement that you depart the U.S. unless you're eligible for another status to go into, et cetera. Certainly, if somebody is married to a U.S. citizen, they may have an option to file for permanent residence or be sponsored by that spouse, or I should say a U.S. citizen or permanent resident. The processing times may vary, and it may not always allow you to remain in the U.S. during that period of sponsorship. But that would be an option if you're starting a family and you have that family-based sponsorship option to consider. But merely starting a family while you're in TN status is not necessarily going to allow you to remain in the U.S. in TN status.
Okay, thank you. I think that's what they were getting to. You might be covering this briefly in your permanent resident section, but I've got a question. I guess it's appreciating your thoughts on this, is whether a person can go, would you recommend going from a TN visa straight into a green card process, or do you need to transition first to an H-1B or some other visa status before you can apply for your green card?
Sure. If you want to flip to the next slide, I can address that at the same time.
Sure.
And as I said, once you're into the green card process, it's very important that everybody work closely with their HR and also their immigration service provider, because there's significant factors that go into account with regard to the green card strategy, and also, whether it's travel questions or work questions, timing. There's so many different factors that come into play. But just as a brief response to that point that Sasha brought up, as Audrey had said, the TN requires that the TN visa holder maintain non-immigrant intent. So the TN visa holder cannot intend to immigrate to the U.S., otherwise it's a violation of their TN status, right? So the TN is a non-immigrant status. Starting the green card process is clearly an expression of intent. However, the green card process itself is it's a three-step process generally for a TN visa holder. So you'll see on the left-hand side, labor certification, which is the labor market test. And then there's the second step, the immigrant petition, and then finally the adjustment of status. The first step of the green card process, labor certification, is prepared by the employer. It's a test of the U.S. labor market. So there's really not an expression of intent on the TN visa holder's side at that point. It's a little bit of a gray area. I mean, to be very conservative and very straightforward, we normally would switch somebody from a TN to an H-1B or an L if possible, because only the H-1B and L-1 visa categories allow for dual intent, meaning you maintain your non-immigrant intent, but can also intend to immigrate if and when possible. So H's and L allow dual intent, whereas TNs, E's, O's, and other visa categories require that you maintain non-immigrant intent. So again, work closely with your immigration service provider if you're in one of those visa categories that requires non-immigrant intent, primarily E, TN, O, and you're ready to start the green card process. Because as I said, your service provider, immigration service provider, will talk to you about the green card process, and really the first two steps, the labor market test and the immigrant petition, are filed by your employer on your behalf, but yet you individually, as the non-immigrant visa holder, are not taking any steps to file the perm or the immigrant petition. It's only at the third and final step that the visa holder files an application to adjust their status. So that was in response to the question. And then just one more minute on the, if we just go back for a second, Sasha, to the previous slide, the two-step process on the right-hand side, this is where you can bypass the labor market test. And this is really for people who are multinational managers, so maybe in the U.S. under an L1A, something you might want to look into for the green card process, or those who possess extraordinary ability, meaning, the top 1%, 2%, 3% of people in your field, or if you're an outstanding researcher, or you're working in the national interest, or the investor EB5 category, where you're ready to invest $500,000 or $1 million in the U.S. And meet significant other criteria. That's also a green card route. And then just finally, the next two slides talk about, again, the labor certification process, as well as where a labor cert is not required. And then, Sasha, if we could just go to the slide that says visa quota. This was in response to somebody had submitted a question prior to the call today, wanting to know what determines where they are and when they'll get a green card process or a green card issued. And really, the points that come into play to determine when you're going to get your green card are your country of birth, the green card category. You can be first, second, third preference generally. There's also fourth and fifth, but we'll just normally for employment-based cases, it's going to be first, second, or third preference category. And then the priority date, which is the date that the first step of the green card process is filed. We talked about the H-1B quota, and there's also quotas on the number of green cards. So all these come into play. And then, Sasha, the next page, which is the final slide, is the visa bulletin. And this, every month it gets issued and determines at what point you'll be eligible to apply for your green card. So I'm sorry, I think we're at the cutoff point. It's been a pleasure speaking with everybody. And again, I think the takeaway here is that immigration has become much more restrictive and much more needs significant attention. And working with your HR and your immigration service provider is of paramount importance in this day and age. Sasha, did you have anything you wanted to say?
Yeah, thank you. That my biggest thing is to say thank you. We've got a few more slides here. Just being cognizant of the time, we are at the 1 hour mark. So what I will do is I will take the questions that we have not necessarily addressed within the session, and we'll share these with both Audrea and Martine to see if there's anything they can respond, and we'll get back to you directly on that. Because just don't want to keep everybody on the line for too long. Just be cognizant that I will also send this recording over to all of our attendees with the follow-up email, so you'll have this information. If there was any points that you had missed, you can refer back to it. I'll send that over in a day or so. So I'll end our webinar here. I'd like to again thank you, Audrey and Martine, for the expertise and the insights you've shared. We've really appreciated your time. Thanks to our online audience for the interest that you've taken to our ACOS webinars, and we will, as I said, respond to your questions following this webinar. Just a quick shout out to ACOS. Our next webinar is on the 27th of September, Global Tax Compliance, and we've got some great in-person meetings coming out in the next few months as well. So it would be great to engage with you all, and thank you all for your time. Thanks again, Martine and Audrea.
Thank you, Sasha. It was a pleasure.
Thank you.